In this lesson, we're concerned to discover the meaning of the 10th Amendment. And in doing that, we want to focus on several things. First of all, we can't talk about the 10th Amendment without the Ninth Amendment, for the two of them encapsulate a dual theory of the Constitution. It is called divided sovereignty when we talk about the federal and the state governments, but it goes beyond that because the people are sovereign. And so it is not that either governmental level is sovereign in itself, but the people's sovereignty is distributed to different entities with limits on how the powers thus distributed are to be exercised. The powers of the national government in particular are limited to those delegated to it by the people in the Constitution. And the purpose of the Constitution is to protect the rights that originate with the people themselves. So the rights do not come from the government. The people bring their rights into the society and they construct the government subject to the organizational principles that we discuss when we talk about divided sovereignty or the twofold theory of the Constitution. The 10th Amendment states explicitly that all government powers except for those specific powers that are granted by the Constitution to the national government belong to the states or to the people. And there is considerable to be said about that. We have but a short time, but I want to emphasize that the very first version of that amendment that was introduced in the eighth clause, as it were, in the debates in 1789 in the House of Representatives, read as follows: "The enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people." And so there was a great debate of whether that was the correct language or not. We won't rehearse all that. But the point, of course, is to say that they proceeded to get to the perfected form by the end of their discussions, just as they did with the First Amendment to the Bill of Rights, which started out saying there shall be no national religion established, and was finally corrected to say Congress shall make no law respecting an establishment of religion, etc., etc. The focus, Congress shall make no law, was meant to emphasize there are powers Congress does not have and cannot exercise. And we need to remember, as we think about the 10th Amendment in particular and the 9th and 10th Amendments together, that the debates were all about the question of adding to the accomplished Constitution a Bill of Rights. Because in 1787 and 1788, when the Constitution was ratified, there was no Bill of Rights. But there had been a commitment made in the state ratifying conventions to add some rights because many of the people who hesitated to embrace the Constitution were skeptical that they could support it without a Bill of Rights. In George Washington's first inaugural address, he said, "We have to fulfill the pledge we made to them to add a Bill of Rights." So the 9th and 10th Amendments are part of the process of fulfilling a pledge made to the people. Why does this pledge take the form it takes? That is what the debate illustrates. And one of the things we're concerned to show is that the whole question of the 9th and 10th Amendments became a question of whether this was meaningful, mere window dressing, or had substance. I'm going to read part of the debate again from August 18th in 1789. "The eighth proposition in the words following was considered. Immediately after Article 6, the following to be asserted as Article 7, the powers delegated by this Constitution to the government of the United States shall be exercised as therein appropriated, so that the legislative shall not exercise the powers vested in the executive or judicial, nor the executive the power vested in the legislative or judicial, nor the judicial powers vested in the legislative or executive. Mr. Sherman conceived this amendment to be altogether unnecessary, inasmuch as the Constitution assigned the business of each branch of the government to a separate department." So see, it started out looking at separation of powers in the national government at one point, and therefore gradually was shifted because the argument was, we've satisfied that. What we haven't satisfied is where the federal government stands in relationship to the state. So the 9th proposition in the words following was considered. "The powers not delegated by the Constitution nor prohibited by it to the states are reserved to the states respectively." Now, you know that's, of course, the 10th adding to it or to the people thereof. But the point, of course, is all of this changes, and the final package of Bill of Rights sent to the states, what became the Ninth and Tenth were really the 11th and 12th Amendments. So that what we have is an ongoing debate in which things are changing constantly. On this particular occasion, there is a proposal made by Mr. Tucker to amend the proposal by prefixing it, all powers being derived from the people. He wanted an express declaration that there is no power that doesn't come from the people. He thought this was a better place to make this assertion. Mr. Madison objected to this amendment because it was impossible to confine a government to the exercise of express powers. There must necessarily be admitted powers by implication, unless the Constitution descended to recount every minutia. Now, I emphasize that because it is Madison who, in the Virginia Report of 1800, inspired what became the clarion call for states' rights in reference to the 10th Amendment. But in the immediate debate, he was careful, he was cautious. He was saying, you can't list everything that can or can't be done, which meant, of course, not only that there are implied powers, as Madison said, but there are reserved rights, more importantly. Yes, there are reserved powers, because that's the language in the 10th Amendment, but there are also reserved rights. And the powers are all derivative from the rights. The powers are not original. The only reason there are any powers at all is because the people have rights. So as the debate continued, they ended up adding "or to the people" to what became the 10th Amendment. Now, as that whole discussion is carried out, what we see developing is a growing sense that there is a desire to avoid the government taking upon itself, the federal government taking upon itself the guidance of state governments. It was Mr. Tucker again who expressed that in the debates. He says, that implies a doubt of the capacity of the states to govern themselves. Now, his judgment was convinced that the particular state governments could take care of themselves, and they deserved to be recognized as such. So, having said all that, we then can put ourselves in mind. We can call to mind, is a better way to express it, what has happened since that time, particularly in the 20th century. There is a chain of events that have transpired in the 20th century that has led to doubt whether there was any meaning whatever in the 10th Amendment. The constitutional interpretation of that amendment by jurists has been fraught with a great deal of confusion until quite recently. Back in 1975, Charles Douglas published an essay on the 10th Amendment. He called it The Foundation of Liberty, and this was in the New Hampshire Bar Journal. But he began that essay by quoting a friend of his who wrote what he called an obituary for the forgotten 10th Amendment. This notion that there was an obituary for the 10th Amendment in 1975 frames then for us the contemporary discussion. For by the more recent years, as recently as roughly 2010, we see an essay on the recovery of the 10th Amendment. So what happened between 1975 and 2010? Well, jurisprudence began to change. It began to change largely under the influence of Justice Clarence Thomas, whose decisions in a couple of critical cases really set things on a differing train and began to call forth the intrinsic strengths of the 9th and 10th Amendment. But let me share with you, before turning to that, a few other observations. This is one from the Honorable Margaret Mary Mangan, who said, "This 10th Amendment recognizes that each state is a real political entity vested with its own personality and therefore with its own powers and purposes. These elements are rooted as well in its own powers. These elements are rooted as well in its own constitution, which serves as the law of its being and its being's end. It follows, therefore, that single free states may lay claim to an ambit of independence in relation with the national government, except, of course, where delegated powers are concerned." Now, that very powerful argument is one that has seen several echoes since that time. It continued in that particular essay, and that was an essay published in the Women Lawyers Journal, making this statement: "It is true that this balance between the federal government and the state governments has been greatly disturbed by the vast extension of federal power since the 1920s under the taxing clause of Article 1, Section 8. But this is not the fault of the 10th Amendment, but the incautious drafting of Article 1, et cetera, et cetera. So we've seen how that has played out in a number of cases, i.e. the commerce power and the taxing powers have been used to expand federal government authority in complete dereliction to the 9th and the 10th Amendments. And so the process of recovering from that is one that takes a good deal of effort. There was a 1989 essay by William Barante, and this was in the Connecticut Bar Journal, in which he said this: the court apparently believed that U.S. representatives and senators are merely delegates of their respective states who will do their state's bidding. Congressmen and senators, however, are not chosen by the states. They're elected by their constituents. Their agendas are not the same as those of their respective state governments. Now, he's making this argument in a case having to do with the government's decision, the federal court's decision about government's powers through school taxing decisions and other relevant decisions where the application of federal law to municipalities and hospitals, et cetera, was affirmed under the Commerce Clause, ignoring the 10th Amendment. Those things led Barante to make this conclusion: the 10th Amendment does not actually limit any delegated power of Congress. It states that Congress does not possess certain powers. Those other powers are reserved to the states or to the people. Congress should not be permitted to assume any reserved powers simply by calling them part of its commerce power. To expect Congress to limit itself in these matters is to ignore almost 200 years of history. The court should reassess the meaning of commerce and thereby restore to the states and to the people control over truly local affairs. Otherwise, the states will become mere agents of the federal government, and the double security blanket of the 10th Amendment will be lost. Now, those are the underlying principles. Many people have commented on these. I've given only a brief selection. But we've seen in more recent years, beginning as early as 1994, an emerging jurisprudence coming from the Supreme Court elaborating this. And this has been done most powerfully by, as I said before, Justice Clarence Thomas, often joined by other justices when, for example, he dissented in the U.S. term limits case of 1994. And that case, of course, overturned term limits for the federal government, Congress in Arkansas. And this is what Justice Thomas had to say about that. I dissent. Nothing in the Constitution deprives the people of each state of the power to prescribe eligibility requirements for the candidates who seek to represent them in Congress. The Constitution is simply silent on this question. And where the Constitution is silent, it raises no bar to action by the states or the people. Our system of government rests on one overriding principle: all power stems from the consent of the people. To phrase the principle in this way, however, is to be imprecise about something important to the notion of reserved powers. The ultimate source of the Constitution's authority is the consent of the people of each individual state, not the consent of the undifferentiated people of the nation as a whole. He goes on to say, because the people of several states are the only true source of power, however, the federal government enjoys no authority beyond what the Constitution confers. The federal government's powers are limited and enumerated. And then in a lengthy argument, which I will not repeat word for word, he then brings forward the 10th Amendment. He says these basic principles are enshrined in the 10th Amendment, which declares that all powers neither delegated to the federal government nor prohibited to the states are reserved to the states respectively or to the people. With this careful last phrase, the amendment avoids taking any position on the division of power between the state governments and the people of the states. It is up to the people of each state to determine which reserved powers their state governments may exercise. So that what Justice Thomas is doing is saying there's no room here for federal courts or even the Congress to try to arbitrate the decisions made within the states about those powers that have not expressly delegated to the federal government, how they should be organized and exercised within the respective states. He goes on further to make this observation. The notion of popular sovereignty that undergirds the Constitution does not erase state boundaries, but rather tracks them. The people of each state obviously did trust their fate to the people of the several states when they consented to the Constitution. Not only did they empower the governmental institutions of the United States, but they also agreed to be bound by constitutional amendments to be ratified by 3/4 of the state. However, at the same time, the people of each state retained their separate political identities. Now, that was a shot across the bow from Justice Thomas. And that shot across the bow turned into a full-blown defense of the 10th Amendment in the Prince case of 1996. And that's a case that had to do with the Brady Handgun Violence Protection Act, an act which sought on the part of the federal government to give immediate direction to state officers, sheriffs, and law enforcement officers. And that was a decision that was handed down in the case with a regard to whether there was power in the federal government to do this. Now, in the course of that decision, a number of things are pointed out, and not the least important of those is, of course, the relevance of the 10th Amendment. And so I'm going to read one passage from the decision. Much of the Constitution is concerned with setting forth the form of our government, and the courts have traditionally invalidated measures deviating from that form. The result may appear formalistic in a given case to partisans of the measure at issue, because such measures are typically the product of the era's perceived necessity. But the Constitution protects us from our own best intentions. It divides power among sovereigns and among branches of government precisely so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day. Now, that led then to a number of further opinions, including concurring opinions and some dissenting opinions. And in the same breath, it leads to observations about the 10th Amendment. This from Justice O'Connor. Although I join the court's opinion in full, I write separately to emphasize that the 10th Amendment affirms the undeniable notion that under our Constitution, the federal government is one of the enumerated, hence limited powers. The Constitution, in addition to delegating certain enumerated powers to Congress, places whole areas outside the reach of Congress's authority. And then, in the meantime, I join the court's opinion striking down the challenge provisions of the Brady Act as inconsistent with the 10th Amendment. So that was the first in a long period of time forthright rejection of a dismissal of the 10th Amendment as having constitutional significance. That is extraordinarily important. So as we have been reviewing this through the lens of the passage of the years, what we've been trying to find, in a certain sense, is where in our constitutional structure, in our history of jurisprudence, the 10th Amendment got lost. So we've seen the observation that it was lost in an overinterpretation of commerce and taxing. This was reflected in some ways in the decision made in the Obamacare era, when the court took the argument for taxation as justifying what they could not justify on the basis of commerce. In both cases, of course, what you're looking at is whether the claim by the federal government doesn't exceed the express powers that have been delegated to the federal government. There are other such examples which are relevant to our discussion, and some of them are so important that they, in fact, ought to engage our attention more fully. I'm going to mention just one at this present moment, and I'll go back to an earlier comment I've made pointing out what one of our analysts had to say about this. But there was a case involving a poisoning, the case of Bond, where one person, a rival lover, sought to poison a rival with chemicals, who was tried under federal crimes based on charges based on an international treaty of violating the International Convention Against the Use of Chemical Weapons. Well, that case ultimately was overturned at the federal level because of the excessive argument made by the federal government that what could have been regulated by the state as an ordinary crime had been ratcheted up and made into a federal matter without any regard for constitutional limits. And the court said, in effect, there's no way to stretch this national security treaty about chemical warfare into a targeted criminal prosecution of an individual who commits an ordinary crime. Because it is, of course, the states that are responsible for health, welfare, and morals in the community. The states, in other words, exercise what is called a police power. That police power is not in the hands of the federal government. And the use of federal treaties or federal legislation, whether through commerce or taxation or anything else, to intrude upon the state's police power is the very source of the violations of the 9th and 10th Amendment that we've known, particularly over the course of the last century. And so part of what we're trying to do is to emphasize the road to recovery from those erosions of the meaning of the Ninth and 10th Amendments.